Call the meeting of the Law Committee to order. Has everybody had a chance to review the minutes from the last meeting?
So moved. Second.
All in favor?
Aye.
Okay, number one, resolution number 80, preventing the hiring of former county legislators and family members. Mr. Mayor?
Yeah, I finally got this into a local law format. Basically what it is within 4 years, while you are a legislator, 4 years thereafter, there'll be no hiring of family members, which is defined on the bottom of the first page here. It does not, if you already have a family member that's employed by the county, you're not affected. Civil service people are not affected. So we have a lot of feel-good resolutions. I guess this is a look-good resolution. I just think it would make us look good. And I know a lot of people say, well, if I want to go work for when I leave office, go work for the county or something. I think it's a little arrogant to say out of 300,000 people in the county that only a legislator or a family member has the ability to go work for the county law. I just, a lot of people disagree with it, but I think, especially right about now, making ourselves look good is not good. That's what
Question. Now, just for clarity, and I know that you've put this before for quite some time, but a question that I have, and I don't know, not to ask and belabor to try to get an opinion, but you have county legislator, and now I know that we're elected, but we're one of the groups of elected officials in the county. Now, because this is only including one, would that be deemed discriminatory when you have individuals, whether it's the district attorney, controller, coroners, county executive, sheriff, any other elected official that's in Albany County? I mean, it seems like that you're pigeonholing county legislators, but not other elected officials. So I mean, it's like you're going so far, but it's kind of being discriminatory. And I don't know if that would, if there was ever a suit, not an attorney, not a lawyer, if that would wind up being somebody could have a suit saying this is being discriminatory against one class of people or elected officials, when you have 6 or 7 other types of elected officials in Albany County. I'm not an attorney, so any other attorney, Mr. Feeney, Mr. Clenahan, Mr. Mackey, our counsel, just for an answer. I mean, if you wish to share an opinion, I'm just kind of curious, and it's not, it's just for my own edification on trying to figure out, if we pass a local law, that it doesn't have suit and or come under some sort of controversy because it could be deemed discriminatory.
Speaking for myself, I mean, I think that certainly is an issue. I haven't researched it, and I wouldn't be able to tell you off the top of my head. I do think that this should go probably to the county attorney's office for review, because I think there are a lot of significant legal questions, and I don't know how the county attorney would come out on it. But for example, when we were talking about former spouses, it seems that pretty broad to me, and I don't know what the law is, but that might be something where a former spouse of a county legislator would say, you can't tell me that I can't apply for a job like everybody else who lives in this town. And not just former spouses, but that might be like the farthest out example that you have.
I think, if I remember, it's been a while, but I think I got that from the lobbying, from the state lobbying rules. I believe I got the definition of family member. And Ralph, as far as the policing, I understand that. But I thought maybe we can start with goes the county attorney. If it gets shut down, it gets shut down. If not, it can expand to any other elected official.
I think this also, I believe, would have to go to a public referendum if it passed, right, because it's an amendment of the charter. And that would be, unless you want to have a special election for this, which probably nobody wants to pay $250,000 for a special election, would be November of 2017. And at that point, this is retroactive to December 31st of 2015, so almost 2 years retroactive at that point. What would happen if somebody has become employed for 2 years and you're retroactive, I mean, they'd be fired?
I think we'd have to amend it.
So, are you ready to put it in this form, or do you want to at least send it to the county attorney and start to get some opinions and maybe sharpen it up some?
I think we should send it to the county.
Okay. So send it to the county attorney for review and opinion?
I will send it to the county attorney.
Okay.
Just a couple of quick questions. I actually don't think it's a legal discrimination issue, because I don't think we're a protected class as legislators. I do think it's a policy issue, and I have some questions there. But just two kind of questions I'll throw out there, and just to think about going forward. Why do we choose 4 years for the revolving door? Because that's double even the state lobbying ban. And that's, arguably more of a good government risk, because you're banning people who worked in government from lobbying for private interests rather than working in a different part of government. And I guess I would echo the chair's question about why, or even if we can do it retroactively, why we're doing it retroactively, and even if we can do it retroactively.
I think after last year's budget, some of the things that went on, personally, I didn't want to see people get rewarded for bad behavior. I mean, what was the budget last year? The vote was 20 to 18, I believe, and a no tax increase budget. So people had concerns, and with some of the things that were going on, that's why I moved it retroactive. And as far as the tour of the 4 years, I think I just chose 4 years. No rhyme or reason to it. I just thought it was the term of the legislator.
The concerns you had about last year's budget, have any of them come to fruition? Or
A couple of them.
so there would be some people who have been hired who would have to be fired then, or else this would have to be amended? Is that what you're saying? And do you know which way you want to go with that?
I mean, it's nothing major has come of what I thought was going to happen at the end of last year.
So the people who have been hired that you were concerned about, you don't want to fire, but this would require their being fired.
Before answering that definitively, I'd like to know who was hired and who you have in mind.
Okay, I don't know.
Wait a second, who was hired should not matter. If it's a policy issue, either you're going to fire them or you're not. They shouldn't matter who they are. This is not aimed at individuals. In my opinion, if you're going to do this, it's aimed at everyone, not just certain people.
Sure, then I wouldn't have.
So if you want to fire them, no matter who they are. It's your decision, though, which way you want to go. But you can't say, well, I got to find out who they are. That just takes the merit out of the whole resolution, in my opinion.
But then we would know if they were a family member. That's what I'm saying, is you have to look at people.
No, you don't. If they meet the qualifications under your statute, they get fired, period. Doesn't matter who they are. That's what you're saying. You can't say this one's okay and this one isn't.
But I guess what I'm saying is that if someone got hired, they weren't family members. I mean, I would like to see the list of people who've been hired since this date. I mean, I can't answer carte blanche here and say this one is okay and this one's not. I mean, I don't know all the people.
It doesn't matter. You're missing my point. My point is it doesn't matter if they're okay or not. They get fired, period.
But I'm saying it does matter because I wouldn't know if they were a family member or spouse or, I mean.
But
You're creating a class here of people, a group of people that would get fired by your definition.
Correct.
And that's all he's saying.
so it doesn't matter who they are. That's what I'm saying.
Right.
Either you want to or you don't. It doesn't matter who they are.
As
Right,
long as they-
you understand what I'm getting at?
They're in the class.
As long as they fit in this class.
That's right.
Okay,
Then they're-
all right, we agree, we're disagreeing and agreeing at the same time.
So, do you want to make any amendments to this before it goes to the county attorney?
No.
Or go to the county attorney, get input from them, and then go forward from there? Okay, all right.
Can I just ask a question reading this? I'm just a little confused. I'm not saying I'm in favor or not, but why are you exempting civil service employees? I mean, if they're a family member and they've scored in the top 3, by what you're saying,
Hello? No, they would be fine.
why?
Hey, how you doing?
Why is one fine and the other not, is what I'm asking.
Because it would not be an appointment, it would be through civil service, through testing, and they would deserve to be there.
So you don't, the other people wouldn't deserve it? I mean,
Possibly.
It's the difference between the classified and the unclassified service. If you're in a civil service position, even if you have a spouse that works directly in the same agency, it's the rule of civil service law based on merit, and your family affiliation has nothing to do with it, as opposed to an appointed position.
except if and I'm not a, expert on civil service by any means, my understanding was like you have to score in the top 3 on the list, okay?
That's-
So then-
No matter what.
My daughter, I'll say, because I don't have one, okay, is number 3. That's okay.
That's okay.
Right.
She's civil service.
There's a lot of precedent on it.
But I see that could be the same, I don't know, I just don't,
Just so,
I'm not saying I want that, okay, I'm just saying, just asking the question. A lot of
and we
questions.
do have a long agenda, so we probably want to get on to
Yeah.
some other items, but it seems to me, civil service just qualifies somebody to be appointed.
Right.
There's still an appointment.
Right.
And wasn't that the concern? Appointment.
No, I think there's a distinction, because you have to finish in the top 3 to even get an interview.
To get an interview, but then if they find those top 3 are no good, they go to the next 3, and they, continue to do that until they get down to the person they want to hire, right?
That's right.
I mean, isn't that,
No, I mean,
is that
you have to.
criticism of?
You have to take someone in the top 3. I don't think you don't go to the top 3, then you go to the next 3. It's,
Oh, well, I always thought that was maybe one of the criticisms of the civil service procedure, is that, yes, you have the top 3, but if you interview those 3 and you don't like them, then you go to the next 3. Maybe
No, like has nothing to do with
that's
it.
nothing.
No.
If you don't think they're a good fit for the position, you still have to.
There are
take
some
them.
disqualifying
Yeah,
things.
yeah,
There's some
okay.
disqualifying
All
things.
right. Well, all right, well, we'll table this at the request of sponsor, and it'll be sent to the county attorney, and we'll go forward from there. Number 2, amending the Albany County Legislative Rules of Order. This tabled at the request of sponsor. Number 3, authorizing 50% of real property taxes collected by the county on the real property conveyed by the Albany County Land Bank Corporation to be remitted to said entity. That's Mr. Higgins. He's not here, so table request of sponsor. Number 4, that's Mr. Drake's resolution, and, here, okay.
Okay, thank you. We did take some time to go back and speak to Executive McCoy's office about the county's willingness to participate in this plan to put the meeting notices, agendas, et cetera, on a calendar that's shared access both to the public and, of course, to legislators and legislative staff. I do have a letter from about a week ago that says that in addition to verbally supporting this, they said that the county is able to, their Division of Information Services is testing the capabilities of SharePoint within Office 365. The SharePoint product does not have the capabilities. However, they are willing to help us in some fashion once we have a platform designed and pass a resolution. They are willing to participate. So we've amended Resolution 220 for the original intent. If you are familiar with the previous submission, if you go down to the last paragraph, number 5, resolved that the meeting notice and agenda for each meeting of the following boards shall be provided to the Albany County IT Department for inclusion on the calendar accessible to the public, then proceeds to list those committees therein. So it has been amended to be a voluntary access program open to the public, and will not include paper memorandums or other physical filings.
Any questions?
Todd, why did you strike the chair in the council's offices? Why not just keep those there?
Well, it could be done, yeah. I mean, the intent, again, was to be sort of a seamless one-step process, but we could certainly add that back.
I can see value in that, just if
Yeah.
each want to reach out to individual members about checking.
Well, originally, this was sort of putting the onus upon those offices to distribute, so we were taking that away,
I
but,
think that makes sense.
yeah.
Address that a little bit also. There was some concern that if they came into the majority minority offices, that they would then become distribution points. And I think there was some discussion in the past from this committee that the committee members would obviously be able to access the public site just as well as the public. So therefore, you'd be kind of duplicative also with the workload that comes through. But certainly, if we were CC'd on it, we would certainly accept the agendas. But that was the reason to look for a portal that anybody could easily access from their home or office or from here.
In addition to that, the portal should be, could be modified, and my intent would be to produce a little more interaction on the part of legislators and other staff with what's going on, and it could have my suggestion was let's say on every Monday at 4 in the morning, it sends out an email that says there's been updates to the committee calendar, click here, or something like that, but it would remind participants to be a little bit more involved and see what's going on with the committees that we're responsible for.
In the paragraph just for the big one there, it actually, that paragraph still says that this would be provided to the majority, minority, and legislative offices, right?
Right, and it's still...
Is that
it's still-
something different that would be provided to them, or is it the same?
No, it's the same.
All right.
So I think
striking it
that the
out
key
in
here is the onus is not upon the offices to distribute it. I mean, that's really the key point, is that it's not going to be additional staff time, et cetera.
Right, for those offices.
Right.
Now, what happens if the boards don't send?
Well, that's a good question. We hadn't broached that question yet. Oops. It'll have to be, I suppose it'll have to be voluntary and subject to oversight. I mean, there's no way to compel them. But-
So when they have their legislative appointments before us and somebody doesn't send emails or post agendas, we're still going to continue to make appointments and everything along that
I think
line?
at that time it would have to be addressed with the chairman of that committee, but that's, I'm not sure that's within our power unless we want to talk to the county attorney about that, but within our power to mandate retroactively.
Any other questions? Do you want to move this tonight? Is that?
Are there further objections or questions?
Okay. I'll open it up to the committee for discussion.
I'm ready to
Anybody?
move forward.
You make a motion to move it forward. Is there a second?
Just discussion on the motion. If you would consider maybe adding chair's office back, I think that might make sense for more dissemination, not giving them the responsibility, but
I think it was,
And what, Brian?
the chairman just pointed out that it's in paragraph 4.
The first resolve clause?
Yeah, the first resolve clause actually names it,
so additionally, okay.
yeah, be it, you know,
Okay.
Okay. Do we have a motion and a second? All in favor?
Aye.
Opposed? Okay. And,
thank you very much.
Congrats.
Number 5, local law J for 2016, and that's Mr. Malowitz.
Yes, the only thing that has to be
Your Honor?
done here is that, I believe, Mr. Miles, the only thing we have to do here is amend your hearing date and send this back to the floor. All right, we hold the local law, but we send the hearing date as amended to October 25th. Is that correct, I believe?
That sound good?
That sounds good.
Okay. Do we need a motion for that?
A motion to amend.
Motion,
yeah,
second.
motion to amend the date.
Second. All in favor?
Aye.
Opposed?
Good job.
Carried.
Thank you.
Okay, number 6, local law K for 2016, and this is Mr. Higgins. Not here, so
That's an expensive one.
table request responsive. Local law N for 2016, and that's Mr. Fine.
Yes, does anyone have any questions on that?
This is going to public hearing tomorrow night.
Right, so we would table this pending the public hearing.
That's correct, and Mr. Ryan and I have
Yes.
discussed.
Okay, so table this at request of sponsor pending the public hearing.
Yes.
Local law O for 2016, and that's Mr. Trey.
It's tabled.
Table, okay. All right. 9, resolution 407, public hearing of proposed local law P for 2016. That's Mr. Cunningham, and I think you wanted to take this together with number 12, right?
Yes.
And what are you're looking to work to
Yes.
consolidate them into one?
So we obviously have 2 local laws. I have met with my colleagues, Joanne and Wynn, and we're working on meshing this into one piece of legislation. So I'm not quite ready to do that tonight, but we're going to do that. We should have no problem doing that. I think what we wanted to do, and I want to speak to you guys, please join me. I think we just wanted to present this to the committee tonight and see if anybody had any general thoughts or questions. I think, and I'll hear you guys speak on this also, but I think our general idea here is we're all aware of the difficulty in pay equity and wage gaps between men and women. Last April, the state passed a pay equity law on a statewide basis, but they didn't include a concept like this one, which would limit the ability of employers who are doing interviews or hiring from asking potential applicants for their salary history. And what a lot of advocates, particularly in Massachusetts, which passed this in August, July or August, what the advocates observed was this was a real way that ongoing wage inequity was being perpetuated, because when somebody came in for an interview, they gave the salary history, all of a sudden the salaries would come down, particularly for women, and that I think having employers, you're preventing employers from doing this would be a way to stop one more avenue of pay inequity. Particularly so if employers are looking for a job, they'll post a job, they'll post a salary range, and that's it. And they wouldn't rely on salary history to lower that subsequently after a hiring or after a job offer. So I think that's our goal here. So I think we just want to present it to the committee tonight in a general sense and see what you thought. And I'll ask Joanne and Lynn if they want to add anything or add much more to that.
I think we pretty much covered it.
All right,
Put
thanks.
the onus on the employer to make the range and not, have it.
Yeah, Ralph?
And then we had some questions, but after you go on with what you're doing, we'll ask them if you haven't.
So it's a range that you're looking for the employer to put on? And then depending
No, I
on
think-
experience, where they would fall in that?
I think that just as an example, anytime an employer posts a job, they would
Yeah.
ask for the range if they're looking to hire in, as opposed to having a range and then later getting the potential employee's salary history and suddenly lowering that down. So we're simply saying with this local law, you can't ask that salary history. If you're trying to hire a job for $50,000, then you're going $50,000.
I know that, again, the county with civil service, there's grades and all that stuff. But how is the county's track record on those non-civil service, appointed ones? How is their track record? Do you know?
I don't know about the county. I can tell you statewide, pay equity is not as great as it is in the private industry, but it does perpetuate. I think one of the bigger problems that goes on in any case is, if you and I work the same job and I make more than you, that's a problem. If you and I work different jobs with the exact same qualifications, exact same education, and I make more than you, that's not a problem. That falls into the gaps. Obviously, it is a problem, but that
Right,
does
you're
not
saying
fall into the
backwards,
statutory
right.
restrictions. So that's one of the things that's perpetuating pay equity, I think, in public employment. I think given civil service, this is obviously more aimed towards private industry.
Correct, but there's a lot of jobs that are outside the civil service and government,
Yeah, true.
Thank you.
Ralph, you had a question? No?
All right, go ahead.
So then 9 and 12, you're tabling? Oh, okay, all right. Lynn, you had a question?
We wanted to know if you thought, something we were discussing is, do you think it would have more success as a standalone thing, or should we tag it on to that omnibus human rights kind of law that sort of covered a lot of hiring practices across?
Probably should be separate, because it's a different issue in many ways.
Can you say that a
It's
little
up to them.
louder?
Yeah. Whether it would be more effective to be in that, I think, it seems to me that either would be fine, but this is meant to address a specific issue, and maybe it would be better to, keep it as a separate local law. either would be effective.
Okay. And then the other question that we had was, I believe that Brian's has some kind of financial penalty if people are, caught doing these things, and that's definitely something that was separate, that wasn't mentioned at all in that other law, and so we were just wondering if, did the merit of it, do you think it would help it or hinder it to have that, the penalty included?
Well,
And we're not asking to move this tonight. so
No, we just wanted to feel how you felt, and
So,
then
yeah,
we would go ahead and,
right, I mean,
Take-
was it up to $250 penalty, is that?
I believe
or
that's
whatever?
That was in
Yeah.
line.
Yeah. So,
Well, we leave that to the committee's discussion, if you have any thoughts tonight, or if you want to get back to us. We're not looking to rush this, I know this is a working process. We need to come together with one thing, but I think just for the committee to consider in the future, what's the best way to prevent this type of action? Is it a fine, is it a cause of action, is it through the omnibus law? Give it some thought, let's start a discussion on that.
Now, real quick, this is a kind of part of a conversation we had, Brian, a couple of weeks or months back. Pass a law like this, how would we know if anybody's fined, or how would we know if anybody had any charges? I mean, from a legislative body that creates and is passing the law, how is it that it comes back to us that we would know whether it was effective or not effective?
I'm not sure it would come back to us, but the conversation we had is exactly why I drew it this way, in that if you were offended by this, you would have a small private right, cause of action, to go get your $250 fine in a local court, which I think, the other option is to rely on a fine by the county, and I think that's what you're getting at in some of our legislation in the past with fines, and enforcement hasn't really happened. So that's why I went for this one, to give it a private right cause of action as an alternative.
ultimately, I guess it would be up to the district attorney to decide to prosecute or not prosecute if this is created.
If it's a criminal, yeah.
Is it a criminal penalty?
Well, it says it will be, it's illegal, and there's a fine involved, so that seems
Civil
to me
law.
like it's a,
Yeah.
a criminal.
I guess because I share a little bit of the concern, I think Ralph is saying, we pass laws, but nobody knows they're out there. And then we find somebody, right away, and we haven't even educated them about the issue and move it forward about whether you should go right out there and find somebody, and everybody has to get lawyers, and so no offense.
Well,
There should be an educational component so people aren't just,
right, any local law that provides for something, providing something will be illegal and provides a penalty, whether it's incarceration or a fine, is criminal in nature. And
Right.
it would be up to the county's prosecutor, which is the district attorney, to choose to prosecute or not prosecute, I guess. We don't have any other prosecutor to prosecute violations of county local laws, right?
Yeah, and again, just a discussion here, but I wrote it in my draft that you could apply to any court of competent jurisdiction, which I would envision that town attorneys, town prosecutors could bring these cases.
town prosecutor
Town court,
could.
village courts as well.
Right.
Not
And they-
just,
and
not
they-
just DAs and state supreme.
Well, I think, right, the local prosecutors.
We don't want to overload a new state supreme court justice.
Local, I think local towns, I mean, their town attorneys, they actually derive the prosecutorial authority through the district attorney. So,
Right.
they have
Still
to
a
actually
district.
get a letter authorizing them to prosecute. Generally, as I've seen it, local laws that the town passes. So if you have a town, they pass a local law, they get a letter from the district attorney authorizing the town attorney to prosecute any violations of that local law. I don't think we have anything like that at the county, do we? So I don't know that towns would ever do this. But in any event, I mean, that's, all good for discussion and public hearing down the road, I suppose.
Can I just say one thing? Related to the last couple of questions, I mean, we pass laws all the time that impose new restrictions on employers and everybody else. And we don't do extra education to make sure that, their HR departments are up to speed. I mean, it's incumbent on an employer to make sure that they're familiar with all state, federal, local laws that shape their human resource department practices. I also think that this issue is gaining a lot of attention, and, you know, the Massachusetts statewide law got a lot of press and media attention, and, you know, I think HR departments are paying a lot of attention to the kinds of questions you can ask for prospective employers. So I don't see it as being sort of off the radar of public discourse or dialogue. I think it's very much in line with some of the pay equity issues that have been brought to light in the past couple of years.
Okay, so we're tabling 9 and 12. And Brian, 10 and 11, those are also yours. Are we tabling those as well? Public hearings, or are we going to public hearing?
So you're capable.
Yes.
Q, that's local law Q, and R, I have it marked here anyway, cable, request to sponsor.
It was, I just wanted to just kind of briefly on those, just, I brought both of these animal rights local laws up, and again, I don't want to rush these, I want to have a full discussion with the committee and other members to see what you think of it, but basically the first one is a limitation on animals in dangerously hot or cold cars, which would, you know, currently under the Ag and Markets Law, there is some ability for first responders to rescue animals like that. This would make it more clear on a county basis, and would also provide that if there was an imminent threat of death and a private citizen had gone through any number of steps to reach out to first responders, police, and all that, that private citizen could also act in a truly genuinely held, you know, near-death situation. So that's the first one.
Can I ask you one question?
Yes.
Real quick? In the Ag and Markets Law, it mentions companion animals. What's the difference between a companion animal and just a regular dog or a cat or another animal?
Companion animal is any kind of
service animal?
Right, exactly.
Okay.
I think it's a little broader than service animal, but yeah.
Okay.
Just one thing on both these laws that when I looked at them, that I thought was good, is it expanded not just for a person, but animal control officers don't have the right to just do that on their own. They have to call for the police. So under this change to the Ags and Markets, it would be good because like Albany, you know, they usually can't get a police officer to go. They're too busy doing other things.
Yeah.
Some of the smaller towns, yes, but that was something, that's really the crux of it, is it expanding the scope of the people that can do that.
Right.
And usually it's the animal control, so I think that's good.
I think that's a really good point. And the way I see this, I mean, animal control officers work in the city, and most of the towns have one, and then outside in the hill towns, they don't, I think, always have animal control officers. The sheriff would operate that fast out there. And the second one is a limit on tethering to tether animals outside in bad conditions, without shelter, without food, without water, for any more than 2 hours. I think the thing in of itself is pretty obvious that an animal on a really tight leash, a really tight tether for a short period of time, totally exposed with no food or water, is a real problem. Even deeper, this kind of tethering, chaining of animals is very common in dogfighting. It's a very common indication of a dogfighting ring where dogs used in dogfighting. So the way I envision this local law is certainly animal protection, but also a more affirmative sort of attack on dogfighting rings as well. So anyway, no rush on those. I'm not asking movies tonight, but just want to see what somebody thought.
I have a question on that one as well. What if the dog is kept outdoors but behind a fence?
It's not tethered.
Wouldn't you want that dog to have the shelter as well? Is it okay to leave a dog outside for longer than 2 hours if it's just fenced in?
Yeah, it is. As long as there's adequate water and the temperatures and the weather conditions.
You don't want it tethered for more than 2 hours.
Right.
So if you live in the country and you don't have a fence around your yard, but you tie a leash around a tree, you don't want that dog outside for more than 2 hours. But if you had a fence, it would be okay for the dog to stay outside for more than 2 hours.
Well, sounds like you may want to expand it, which is not what I expected. But I think it's a fair point. I think in terms of the tethering is the dog has very little freedom of motion, very little ability to move. And the size of the fenced-in area, there may be.
I can understand you maybe having a minimum length of leash. I mean, you don't want a short leash. You want to allow it to move.
Right.
Maybe you should look into a minimum length of the leash versus whether it's tethered or not. Because I think you'll find, especially on the country, dogs do like to be outdoors. And if you have a long enough leash and there's shelter and there's water,
Right.
then, I mean, they're happy.
Right.
So, yeah, you want to work on that just a little
I
bit.
think the
Would
law
you
under
envision-
Ags, yeah. I think under the Ags law, it does account for that. There's a minimum. Because, but one of the problems is too, was it the city, no, the change that he's making.
Oh, okay.
In the city, a lot of people don't have fences in their little yards too. So it's not uncommon for them to tie them up for a few hours, but I think it's making sure that they have all the necessary things and then they can't get tangled up and all that kind of jazz.
Yeah, Ag and Markets Law 353B requires that any person who owns or has custody or control of a dog is left outdoors to provide them with appropriate shelter. Shelter is currently defined as a structurally sound housing facility that is insulated, has waterproof roof, large enough to allow a dog to stand up, lie down, turn around. Law also requires that there be a shaded area away from direct sunlight that is accessible to the dog at all times. So you just want to maybe tweak it a little bit.
Makes sense. And I'm glad you brought up Ag and Markets also, and this is the last thing I'll say to move on, but traditionally a lot of these animal protection things in Ag and Market law have been preempted by the state. A couple of years ago, the state started kind of reversed on that and gave counties the ability to start to police animal rights, animal protection, puppy mills, pet stores, puppy farms, that kind of thing. I think this is more in the trend in that direction of getting the state less involved in these kind of issues, because the reality is, despite these state laws, despite Ag and Market laws, the state has done almost no enforcement on this and almost no animal protection on this. And I think, given the state acknowledging this as they did a couple of years ago and agreeing to get rid of the preemption on those puppy mill laws, I think this is a good step in the direction of giving us local enforcement on these issues, because it's just not getting done otherwise. And that's all I've got.
Okay. Anything else on this? Okay, so 10 and 11 are tabled. We've done 12. 13, public hearing on local law O, that's Mr. Drake.
That's being tabled also.
Table sponsors, okay. 14, public hearing on proposed local law U, and that's Mr. Mendix. He's not here. This is for a public hearing, right?
Even sponsor, that's what we just did with Mr. Drake, Mr. Demowitz, because he missed the last one. The lead sponsor has to be here.
Has to be here. Okay, so table it. Table it, request to sponsor number 14. 15, local law P for 2016, that's Mr. Glenn, table. 16, local law Q, again, that's your table. 17, local law R, and again, that's yours, table. 18, local law S for 2016. This is a local law of the County of Albany regulating the use of polystyrene foam disposable food service. Whereas this is Mr. Kagan.
He submitted, was it last week? He submitted a public hearing resolution, which will be on the agenda this month.
Okay, all right. So we have to table this anyway because we have to wait for public hearing. Okay. 19, local law I for 2016. That's Lynn's.
It's
And
T.
that,
Actually,
T, yeah, sorry. T, and this has to be tabled pending the public hearing, or is this the,
Yes.
right, that's the one you're talking
Yes.
about
Yeah, we're gonna
combining.
hold that,
So same thing, you want to table?
We're going to withdraw one of them at some point, but we don't know which.
All right, okay. All right. 20, local law U, and that's Mr. Mendick, so that's tabled right here. 21, authorizing the submission of a grant application and agreement regarding motor vehicle theft and insurance fraud prevention program. And this,
Nobody here?
nobody here. Table? Motion to
I don't know
table?
if we can. I don't think.
Yeah, I mean, it's a.
That's a
grant
regular,
application,
the regular thing we always do too.
um, But because this is a grant.
Yeah, is this going to wind up, if we table it, is there a time that the
That's,
district attorney may wind up losing out on grant funding?
We could always meet right before the meeting.
We could do a Yes, that's a good
Close
idea.
public forum.
And maybe something happened to the district
On
attorney's
those
office.
three, that's 21, 22, and 23, so we'll table it, and somebody, you'll contact the district attorney.
One I
to see
can
if-
be sure of that.
Okay. See if they,
These are all repeats, too.
Yeah, because you hate to
They're all,
miss
I know.
You would, but I think it's important that the DA come here and
Yeah,
explain.
absolutely.
Yeah.
Absolutely. They usually, yeah, I know.
They're usually pretty good.
Yeah, that's why I'm wondering if something happened, you know?
There was two bank robberies today, I guess, down here.
Oh, were they?
That's what Mert said. Mert, you said two bank robberies, right?
Yeah, I think,
That may be why the DA's got nobody here.
Oh,
Yeah.
Two down Pearl Street.
Yeah.
Pearl?
Motion to adjourn?
M&T and Key Bank were robbed today.
One right next